Ghosh's case, what the trial judge has observed, please go through it. At 2:30 a.m. in the night.
Yes, the mail was given to the
it was
officer.
sent, and
that was sent from my BS.
so you
no mails.
are a hardworking lawyer. Your office works 24/7. It is.
Would your lordship want to see what had happened with me? Ultimately, what your lordship, I'll just show because I'm also bound for compliance. This is what we deposited in the lower court. Malad kindly sees, we are in a slightly different situation, Hazra. Malad sees paragraph number 3, 7, and 8. We are very grateful to CBI. They were cooperative, but there are some issues which are there, Malad. Sees paragraph number 3, paragraph number 7, and 7 and 8. So far as we were concerned, we got first day we got an inspection chance of 345 to 482. Right? But there were about being total 137 documents, Malad, where substantial documents were missing. Malad, we indicated that in Annexure P3. After that, Malad, your lordship's pleasure would be to kindly come to number 7, paragraph number 7. On the next day, Malad, we got an inspection of total 79 documents. Now, Malad, the issue is that we came to know, the representatives came to know that there are different IOs involved in this investigation. The name of our IO, so far as Shumon Hazra is concerned, his name was Ashutosh. He was dealing with us. So he said that we are going to take out, the investigating agency is going to take out piecemeal manner. That's the reason why first day that lot came out and the second day this lot came out. So we got this to see and we indicated what documents we do not have. We did not get so far as this is concerned. And paragraph number 8 is the total managed to produce 216 documents in 2 days. That's about 14 hours today, 266 is left. Now I leave it upon your lordship whether
266 is left is in.
We have been able to, out of 482, the CBI gave us 216. We indicated what we've not been able to see over there also. CBI has given us pen drive which came to us last evening. We've not been able to verify that much. But however, we have got to see 216 documents and what is remaining. Now 266 is left out of 482. Yes.
We follow that you have inspected. According to you, inspection is not complete. Further inspection of documents are necessary. In the meantime, Mr. Majumdar proposes that, and also the order of the trial judge indicates that by tomorrow, they are going to supply all the scanned copies of relied upon to all the accused persons. Correct? Since the amount is voluminous, we are giving you 7-day time. We are keeping it on Tuesday again at 10:30 a.m. All right. In the meantime, please go through it, and we will request the trial judge to place this matter any day prior to the next hearing, subject to the convenience of the court, and get your responses on
what we are not getting,
what you have not got.
Yes, Madam.
All right. So
yes, Madam.
We keep it on Tuesday. The judge can keep it on Monday or on Saturday because it's a working Saturday, I think. So we don't want to burden the judge with a specific mandate.
Right.
We keep it loose. We will say that in the meantime, either on Saturday or Monday, as the judge's convenience, can fix it so that you can exchange the views, get an order, and again, we sort of supervise the exercise. Our endeavor to do that, we have made it very clear on the last occasion, is to iron out creases, remove any perception of unfairness or hastiness in the trial process, but also not allow the excuse of the due process as a subterfuge to derail the trial.
Yes, sir.
Right? We'll do that.
Only one.
But the other accused persons, you are for Afsar, you have no opposition, you are happy. What we propose to do for the others is they don't have any objection as such, but when the scanned copies are supplied, you will look into the scanned copy and the hard copies and make your observations before the trial judge on the next day.
My Lord, just one clarification subject to what Mr. Majumdar will say. If we have an issue, can we revert to CBI?
Definitely you can revert.
No, that is the reason your lordship is
No.
giving a date
That
before
was
the
till the
trial
time
court.
the direction was there.
Sir,
Just
which Pradip Ghosh's case, what the trial judge has observed, please go through it. At 2:30 a.m. in the night,
Yes, the mail was given to the
it was
officer.
sent, and
that was sent from my BS.
so you
no
are
mails.
a hardworking lawyer. Your office works 24/7. It is appreciated, sir.
We had a
The
timeline.
thing is that at least then next day inform the CBI officer that at 2:30 a.m. we have sent a mail.
No, after that everything got
And your
regularized.
lordship can remember, and your
2:30 a.m. 41A notices. But we have never seen lawyer emails at 2:30 a.m. to the police officer.
and your lordship
the time will expire.
We were
No, your lordship-
The other day, your lordship, the way your lordship
Very clear.
reflected.
We understand this is spoken on a more lighter view.
No, absolutely.
We understand your urgency, etc. Your clients are in custody. We would definitely not do anything which will protract your detention and pain. But
Most of
the trial should immediately start. Framing consideration of charge. What we propose to do is by the end of this week, the supply of document exercise.
once electronic comes, let us compare through electronics.
Let it
We'll compare through electronics.
that will suffice the purpose.
Let us compare through electronics.
Yes,
Regarding-
Mr.
Regarding maintainability of this appeal, may I submit one thing, just only one.
Open Raj.
we are
Yes, I
very
know that.
well conscious of Ram Fauji.
No, I'm just, give me 1 minute time. Well, on 23rd of August 2024, this Honorable Court, Lana single judge of this Honorable Court passed an order for CBI investigation. Now, we are challenging that they moved the Honorable Division Bench
No
says,
Supreme Court.
directly then go to the Supreme Court.
They went to
Division Bench, thereafter Division Bench.
no division.
Division Bench.
No division.
He was shot for my lord.
So all that stories are useless.
No, right.
No, Mr. Counsel. No list was filed before the division bench. There may
He
have
was shot for my lord, I can say.
sir, leave was sought for is nothing. Zero.
Now, thereafter it went to the Supreme Court.
Correct.
Now,
We are not looking into the issue of transfer of investigation. We are putting a question to you, clear and simple. If a review petition is rejected, is the appeal maintainable under clause 15 or under order 47? Tell us.
so far as they have not filed a review.
We are treating the recalling application as
That
written.
your lordship will kindly see will the review.
We are treating the recalling application as written.
I have nothing.
Yes, don't open that.
No, my lord,
I made it very clear to your junior on the last occasion. A order is passed by the single judge. The order, in our understanding, was only an observation of the bench. It had no mandatory import. What it resulted in was a avalanche of consideration without even due process being followed. This order was passed without hearing some of the accused person. In our understanding, they had a right to file for recalling.
Yes.
Correct, because the principles of
Yes.
natural justice not followed.
Budhia Sahaj case is there.
Correct.
Yes.
Second was the judge considered the delay primarily on the anvil of
Sanction.
grant of sanction in 2 months. We indicated to Mr. Mujumdar, the law gives 3 + 1 month to grant sanction. That is not to say that the sanctioning authority would always take 4 months. But when we test 2 months as reasonable or unreasonable, we have to test it on the anvil of statutory limitations. Now, the statutory limitation being 4 months, sanction being granted in 2 months, will that trigger a direction for extreme urgency so that the consideration of charge is advised? We would use the word advised to the trial court within 7 days. This is where the review or the recalling was necessitated. The matter was placed before the Honorable Single Bench. Honorable Single Bench rightly wrongly observed, I am being called upon to decide, reopen a closed list on the basis of subsequent events. Nobody was asking, in our understanding, subsequent events. The review could have been easily disposed of, or the recalling, by saying the observation of 7 days was nearly directorial and not a mandate so as to take away vital
Statutory
rights
provision.
of parties which are germane for a fair trial or steps leading to a fair trial. That is where the appeal lies. The appeal, Mr.
Mr. Tiwari.
Tiwari, Mr. Tiwari, the appeal, Tiwari brothers. The appeal, Trivedi is there. Trivedi is not interested. He is ED. Now the game will start, sir. The day Mr. Trivedi's client files the complaint, lock, stock, and barrel, it goes to the special court.
Yes.
The entire thing will go to the special court under the PMLA Act, right?
Yes.
So we'll cross that bridge if at all we need to do in this proceeding. When this was brought to our notice, Mr. Mojumdar, your junior, pointed out to us that, see, Ramfoji is there. I understand Ramfoji was decided. Honorable another coordinate bench referred it to larger bench. What we told them is, now if you go into this question,
It will be
you
dragged.
are actually falling into
Yes,
the
yes.
trap of the accused persons.
Dragged.
They will be the happiest that all of us hear learned arguments on maintainability, and they get a wonderful time going to the bail bench and saying, my lord, see, maintainability is being argued, please give me interim bail. Right.
We'll come back here only.
Article 21 will come.
We administer law realizing ground realities. We don't interpret law in vacuum. So in our first order, you will find
Yes, yes,
we have
I've seen
kept that
the point
maintainability to
open.
be decided and appropriate, but we have said that immediate need is to put this proceedings on rail
Yes.
and keep these persons on a tight leash. Because first thing, what we did? The earlier, my brother was not there. Put the other two accused
As per
on
form.
board because we know what is going to happen. Again, the same thing which is before Justice Ghosh would be repeated. My lord, we were not heard. So everyone come on board. Secondly, we said Saturday, Sunday also don't lose. Go to CBI office, examine and compare. Go back to the trial judge, we keep it today. So we are at this stage. That is why, Mr. Tiwari, we are saying, in our understanding, your argument on the first appeals or the appeals against the initial order, well taken. Ramfoji may stand in the way. But tell us one thing, and we would like to hear you on this. Ramfoji restricts clause 50. But a recalling application, be it described in whatever manner, if it partakes the character of a refuse and is refused, will the appeal lie? And I know your experience in civil law, that's why I am telling you also, Mr. Trivedi. Will the appeal lie under clause 15 or under order 47?
Clause 40 is there. Let us put in its interlocutory orders has been passed. Then appeal will
As good as Khimji interlocutory order determined.
Yes.
What is an interlocutory order? Any order which affects vital right of party is an interlocutory order. So our understanding, when the order, the judge may consider 7 day. Judge will consider framing of
consideration
charge within
7 days
7
on the
days.
next day.
Has an impact of the consideration being done on 4th itself. Partakes the character of an order which affects vital rights of parties. There cannot be any quarrel on the proposition that it is an interlocutory order or not. It is affecting rights of parties. There we take into consideration the subsequent event. Not that the subsequent event is challenged. Subsequent event is, according to the appellants here, a consequence of the
That order.
direction.
Yes.
So that direction is understood by the trial judge as a mandate. So it is our requirement to explain whether it is a mandate or not. The Honorable Single Judge could have done it in the recalling application itself, chose not to do it on the ground that
Diffuse and disposed of.
it is subject. This is the limited scope of the appeal, Mr. Tiwari. You want us, we can decide it now, but we choose
No, no,
not
keep
to
it
do
pending.
it now.
Keep it, Malad. That was the submission I made before the learned.
Share with us without being in some way prima facie satisfied that there is an arguable case on maintainability. We would not have passed.
Sir, I am not raising that issue.
And Milord, in 4G,
I am not raising that
Milord, in
issue.
4G, it is also there. Milord, if the civil right is affected, then Milord, latest patent 15 is maintainable. Milord, here, what has fallen from your lordships, audio altem partem, they were not heard. But that may be a civil
Something
right.
What we
Yes, Milord, we shall argue on this. We shall
and in
argue
our
on this.
order, we have indicated 2 or 3 things. One is Hajra not being heard. He has a right to file a recall. Secondly, judge observing 2 months is an inordinate delay in grant of sanction without adverting to a statutory time limit under the Prevention of Corruption Act is a question of review or recalling, whatever you say, a legal provision not being considered. The third was the ratio of High Court of Judicature Allahabad impact of paragraph 47. Although it says that in exceptional cases
Exceptional
you
case it can be
can
done.
give it, but what was the exceptional aspect in this case? Delay in grant of sanction. That is what the judges considered as exceptional. In doing that, judge did not advert to the statutory,
Requirement.
not requirement, the
Mandate.
statutory timeline for grant.
Mandate.
So naturally, they should.
No, I understand, Milord. Keep this point pending, Milord. We
My
shall
lord,
argue before
please
your lord.
consider this, and thereafter, if you feel 7 days is good, we go back. His lordship holds, no, you are challenging the subsequent order of consideration of charge. Our understanding, subsequent order was only a consequence of that
Consequential order of
observation.
the.
This is where Mr. Tewari, we felt prima facie, but we didn't want to observe it because we had not heard you, and frankly, it was the first day. It was off the cuff. Our understanding was also off the cuff. So, lest we be embarrassed by our own ignorance,
What is to property?
we kept the issue open. We kept the issue open. But what we felt was that we should not give these people a long rope, these accused, because if we give them a long rope, 2026 charge will not.
No doubt about that.
With the ingenuity of Mr. Banerjee and Mr. Bhattacharya et al., I am confident the charge will not be framed before 26. This I can assure.
This is being recorded, Malad.
Thank you, Dr. May say,
That is your, that's our appreciation. Please
Then
don't
don't.
don't consider it as a judicial observation.
No, no,
It's
no.
all, as we said,
It's on a light.
on a lighter vein, and it is absolutely clear, at least from our end, and I would definitely say even the complainant will never say, far less CBI. In fact, Mr. Mojumdar also said, yes, there is quite a lot of documents, let them compare.
Yes.
It was more in the nature of a consented order. And your junior was there, so poor girl, we didn't want to embarrass her.
And another
That-
new law.
That another reason why we kept that maintainability open, that we will hear you on.
Deeply obliged for.
All right, thank you.
Finally, do we compare or don't we compare with the original which is there in CBI?
We are giving a scan copy.
Scan
we'll see the scan copy.
Scan copy, and you can compare, and you can request CBI to supply
Along with the umbrella
documents. We will pass the order. Please listen to us. CBI has submitted report. In the report, paragraph 10 of the report reads as follows. Set out paragraph 10. Paragraph 10 to 12 of the report reads as follows. Full stop. The report also indicates that on 10/2/2025, the matter was heard by the learned trial judge, and the judge observed the learned counsels for Shondeep Ghosh was making baseless allegation accusation against the agency. Good stop. Furthermore, it is recorded in the order that scanned copies of the relied documents shall be supplied to all the accused by tomorrow, that is 12th February 2025,
No, no, scan copy কালকে দেবো।
as per 12th February 2025. Good stop. Learned counsel for Shandip Kumar Ghosh. Shandip Ghosh, are you still a doctor, or your medical degree is
It was cancelled, but
suspended?
this suspended. There's a writ notice.
Cancelled, but it was challenged in
Like you cannot.
No, it's cancelled.
medicine as of-
It's cancelled. That I
We are
cannot do
not
practice.
describing you as a doctor. As Shandip Ghosh contents